I have presided over thousands of hearings during my years on the bench. I've watched careers collapse in a single afternoon. I've watched innocent people break down with relief after years of carrying burdens they never deserved. I've watched practiced liars fool almost everyone in the room, almost everyone. But there is one case I still remember with unusual clarity, not because it involved millions of dollars, not because anyone was famous, and not because it changed the law. I remember it because Arrogance walked into my courtroom believing it could put justice on trial. And for a few unforgettable minutes, it almost succeeded. If you're watching this, let me tell you something I've learned. After decades behind the bench, most people think a courtroom is about evidence. They're only half right. Evidence tells me what happened. People tell me why it happened. That morning looked ordinary. The calendar was full. The hallway outside buzzed with lawyers rehearsing arguments, litigants whispering to family members, and deputies trying to keep everyone moving on schedule. Nothing suggested that this hearing would become one of the most talked about moments I ever witnessed. Then the defendant walked in. His name was Ethan Brooks, 34 years old, tailored navy suit, expensive watch, perfectly styled hair. He didn't enter like someone appearing before a judge. He entered like someone arriving for a business meeting where he expected to be the smartest person in the room. I've seen confidence. I've seen fear disguised as confidence. This wasn't either. This was contempt. He barely glanced toward the clerk. He ignored the bailiff's instructions. And when he looked at me, he smiled. Not politely, not nervously. It was the kind of smile that says, "You can't touch me. Believe me, after enough years on the bench, you learn that smiles can reveal more than sworn testimony." Across the courtroom sat the plaintiff, Sarah Mitchell, 41. A small business owner. Her hands trembled as she organized documents inside a worn leather folder. She wasn't looking at Ethan. She kept staring at the evidence she had brought. People often misunderstand nervousness. Jurors do it, viewers do it. Even lawyers sometimes make that mistake. They assume nervous people are hiding something. Experience teaches exactly the opposite. People telling the truth are often terrified. Liars usually arrive prepared. Sarah looked terrified. Ethan looked entertained. That contrast stayed with me from the very beginning. When I asked both parties to identify themselves for the record, Sarah answered immediately, clear, respectful, quiet. When Ethan spoke, he leaned back in his chair. "Your Honor," he said, "I hope we can make this quick. I have clients waiting." The courtroom became strangely still, not because his words were offensive, because of how he delivered them. There was an assumption buried underneath every syllable. His schedule mattered. Mine didn't. The court's didn't. Justice could apparently fit itself around his afternoon appointments. I've heard countless versions of that attitude. Some people believe success places them above accountability. They're almost always wrong. I simply nodded. "You'll leave when the hearing is finished." His smile widened. "I figured you'd say that. No apology, no adjustment. Just another challenge. You might think judges become angry during moments like these. Actually, the opposite happens. The calmer I become, the more concerned the other side should be, because emotion clouds judgment, patience sharpens it." The plaintiff's attorney stood and began outlining the dispute. On paper, it looked almost ordinary. A business agreement, a broken contract, missing funds, several disputed electronic transfers. Nothing unusual, except Sarah's attorney kept emphasizing one phrase. Intentional deception, not negligence, not misunderstanding. Intentional words matter inside a courtroom, especially that one. Across the room, Ethan quietly chuckled. Not loudly enough to interrupt proceedings, just loudly enough for Sarah to hear. I noticed her shoulders tense immediately. That reaction interested me. Victims don't usually react to insults. They react to reminders. Whatever history existed between these two, it ran much deeper than the paperwork suggested. I asked Sarah a simple question. When did you first realize something was wrong? She inhaled slowly. I trusted him. 4 words, nothing more, yet those 4 words carried more emotional weight than entire opening statements I've heard over the years. Trust once broken, every transaction afterward becomes evidence. Ethan rolled his eyes, actually rolled them, inside my courtroom towards someone giving sworn testimony. You would be surprised how revealing small gestures become under pressure. Words can be rehearsed. Bady language usually cannot. I made a note, not on the legal pad in front of me, in my mind. Because tiny moments often grow into enormous truths, Sarah continued explaining how Ethan had approached her company months earlier with promises of expansion, new investors, and larger contracts. Everything sounded polished, professional, convincing, until the money disappeared. The defense attorney finally stood. He was experienced, measured, careful, unlike his client. He argued there had been misunderstandings, poor communication, different interpretations of contractual language, reasonable points, legal points. Then Ethan interrupted his own lawyer. I could explain it better. That sentence alone made several attorneys sitting in the gallery lower their heads. Lawyers know something many clients never understand. Interrupting your own defense is rarely a good idea. I looked directly at him. Mr. Brooks. He stood anyway, confident, relaxed, almost amused. I think everyone here is overcomplicating this. The room became silent again. Not because anyone expected brilliance, because everyone sensed he was about to make a mistake. And sometimes, the most damaging testimony isn't extracted by cross-examination. It's volunteered by arrogance. He adjusted his jacket, looked toward the jury box, then turned back toward me. If people are foolish enough to sign paperwork they don't understand, he stopped just long enough, just one heartbeat. His attorney whispered something urgently, but it was already too late. Because in that single unfinished sentence, I realized this case wasn't about missing money at all. It was about something far more dangerous. And what I noticed next, something almost no one else in the courtroom had seen, would change the entire direction of the trial. The moment Ethan Brooks cut himself off, I watched something remarkable happen. His attorney's face lost all color. It wasn't dramatic. It wasn't theatrical. Years on the bench teach you to notice changes measured in fractions of a second. A tightened jaw, a swallowed breath, fingers gripping a legal pad just a little too tightly. His lawyer knew exactly what had almost slipped out. So did I. The jury, however, only sensed that something was wrong. They didn't yet understand why. That's one of the great misconceptions people have about trials. They imagine dramatic confessions and shocking outbursts decide cases. Most don't. Cases are often decided by tiny fractures in carefully constructed stories, and I had just heard the first crack. I instructed Ethan to sit down. He hesitated. That hesitation told me more than his words ever could. People accustomed to getting their way often struggle with simple instructions when they're no longer in control. Eventually, he sat, but not before flashing another confident smile towards Sarah Mitchell. She never returned the look. Instead, she kept staring at the folder resting on the table in front of her. Not at me, not at Ethan. At that folder. If you've spent enough time in a courtroom, you begin to recognize emotional anchors. Some people grip a wedding ring. Others hold on to a photograph. Sarah held that folder as though it contained the only thing keeping her standing, I asked her attorney to continue. He approached the evidence monitor. "Ladies and gentlemen," he began, "the defense would like this dispute to appear complicated. It isn't." He displayed the first exhibit, a signed consulting agreement, nothing extraordinary, then another, bank transfer records, Agan, nothing unusual. Several jurors glanced down at their notes. I could almost hear them wondering where this was going. So was Ethan. He leaned back in his chair with the confidence of a man convinced he'd already won. Then the attorney displayed a series of emails, professional, polite routine at first glance. "Your Honor," the attorney said, "I'd like to direct everyone's attention to the timestamps." Now the room became attentive. The emails showed Ethan reassuring Sarah that investor funds had been secured. He promised payments were being processed. He insisted delays were caused by banking procedures. Each message sounded believable, convincing, even, but courtroom experience has taught me something. Liars often hide behind excessive detail. Truth usually arrives much simpler. The attorney zoomed in. One email, another, then another. Every message had been sent within minutes of substantial withdrawals from company accounts. Withdrawals Ethan claimed didn't exist. The defense objected. Correlation is not proof. A fair objection. I sustained it because procedure matters. Never sacrifice fairness simply because one side appears less sympathetic. That's the responsibility of a judge. Justice isn't measured by emotion. It's measured by discipline. Still, I noticed Ethan's confidence begin to shift, barely. His posture changed. He uncrossed his legs, adjusted his tie, reached for water he hadn't touched all morning. People rarely realize when anxiety first appears. It doesn't begin with panic. It begins with discomfort. The smallest physical adjustments reveal the biggest internal battles. Sarah's attorney wasn't finished. He called his first witness, a forensic accountant named Rebecca Collins, calm, methodical. No dramatic language. Exactly the type of witness juries tend to trust. She explained financial tracing in plain English. Money leaves footprints. Electronic transactions leave even more. Every dollar has a destination. Every transfer creates a timeline. And timelines rarely lie. Ethan listened with folded arms. Occasionally he smirked. I found that interesting. Experienced defendants usually avoid visible reactions during expert testimony. He appeared convinced none of this mattered. Or perhaps he wanted everyone to think he was convinced. There's a difference, Rebecca continued. She showed how funds moved through multiple business accounts before arriving at companies connected to Ethan, not directly, indirectly, complicated, deliberately so. The defense immediately argued those companies were legitimate vendors. Agan, a reasonable argument. Nothing had yet crossed the line into undeniable proof. I reminded myself not to jump ahead. A judge must resist assumptions even when instinct whispers otherwise. Then Rebecca said something that caught my attention immediately. "We found one transfer that doesn't fit the pattern." She paused. Only briefly. The defendant tried to reverse it. Now Ethan looked up. Fast, far too fast. Years of observing testimony have taught me another lesson. People react most strongly to facts they weren't expecting. Rebecca explained that one transaction had been canceled just minutes after it was initiated. Why? No one knew. Not yet. But canceled transfers often preserve metadata. Information people believe disappears. Sometimes technology remembers what human beings hope it forgets. Sarah quietly wiped away a tear. She wasn't crying because money had been mentioned. She was crying because someone had finally confirmed she hadn't imagined what happened. Violation is powerful, more powerful than compensation. I glanced toward the jury. Several members were now leaning forward, not because the evidence had become dramatic, because it had become personal. Everyone has trusted someone. Everyone has believed a promise. Everyone has wondered whether they were being manipulated. Good cases connect evidence to universal human experience. This one was beginning to do exactly that. The defense attorney stood for cross-examination. His questions were precise, professional. He challenged Rebecca's conclusions, suggested alternate explanations, raised technical concerns. She answered each one calmly, no hesitation, no exaggeration. When he finally finished, I noticed something unusual. Instead of looking relieved, Ethan looked irritated, not nervous, not frightened. Irritated, as though competent witnesses were inconveniencing him. That attitude would prove far more damaging than he realized, because juries forgive mistakes. They rarely forgive contempt. The afternoon recess approached. I announced a short break. People stood, the jurors filed out. Attorneys gathered their files. Deputies escorted everyone into the hallway. I remained seated for a moment, reviewing my notes. That's when something happened that wasn't captured in any official transcript. Something only a handful of people in the courtroom actually noticed. Ethan believed no one was watching. He leaned towards Sarah. His expression changed completely. The charming smile disappeared. His eyes became cold, calculating. He whispered just 4 words. Words so quiet that most of the courtroom never heard them. But I did, and so did the bailiff standing only a few feet away. I warned you once. Sarah froze. The color drained from her face. The bailiff immediately stepped between them. Ethan leaned back in his chair as if nothing had happened. Then he smiled again. That same confident smile from the morning. Only this time, I knew it wasn't confidence. It was control, or at least his desperate attempt to keep it. And at that exact moment, I made a decision that would change the rest of the trial. Because what the jury didn't know yet was that new evidence had just arrived at the courthouse. Evidence that neither attorney had expected. Evidence that, if authentic, would expose a lie so devastating that even Ethan Brooks' own defense might not be able to save him. When I returned from the recess, I noticed something I had learned never to ignore. The atmosphere had changed, not dramatically, not loudly, just enough. Courtrooms have a rhythm. Attorneys settle into their arguments. Witnesses follow procedure. Jurors become accustomed to the pace. But every once in a while, something invisible shifts. That afternoon, I felt it the moment I walked back onto the bench. The clerk handed me a sealed envelope that had been delivered during the break. It wasn't unusual for additional evidence to surface during an ongoing civil trial, provided the proper legal foundation could be established. What was unusual was the expression on the clerk's face. She had worked in my courtroom for years, professional, unshakable, yet even she seemed unsettled. I didn't open the envelope immediately. Procedure comes before curiosity, always. No matter how compelling something appears, a judge who abandons procedure abandons justice itself. I announced that counsel should approach the bench. Both attorneys did. Ethan remained seated, though I noticed his eyes following every movement. His attorney looked confused. Sarah's attorney looked cautiously hopeful. I informed them that new evidence had been submitted by a third party claiming direct knowledge of the disputed transactions. The defense objected immediately, as they should have, I thought. Good attorneys don't fear evidence. They fear surprises. I instructed both sides that nothing would be admitted unless authenticity could first be established. That decision disappointed everyone equally, which usually means it's the correct one. I've often told young lawyers that a courtroom is not a television drama. No one wins because something shocking appears at the last second. Every fact must earn its place. Still, even before the envelope was opened, I noticed Ethan doing something he hadn't done all day. He stopped smiling. Not entirely. But the effortless confidence he'd carried into my courtroom had begun to fade. His fingers tapped the table once, twice, then stopped. Tiny movements, most people overlook them. Judges cannot afford to. I asked Sarah's attorney whether he recognized the name of the individual who had submitted the materials. His eyes widened. "I do, Your Honor." "Would you care to explain?" He nodded slowly. "The documents appear to come from Mr. Brooks, former executive assistant." That single sentence changed everything. Ethan's head turned instantly toward his lawyer, not toward me, not toward Sarah, toward his own attorney. Believe me, when defendants stop looking at the judge and start looking at their lawyer, something significant is happening inside their minds. The defense requested time to review the materials. Granted, fairness required nothing less. While both legal teams examined the documents, the courtroom settled into an uneasy silence. No whispers, no movement. Even the spectators seemed to understand they were watching the direction of the trial change in real time. I used those few quiet minutes to observe the jury. People assume jurors only listen. In reality, they're constantly watching. Who appears nervous? Who avoids eye contact? Who suddenly changes behavior after new evidence appears? Jurors notice far more than attorneys realize, and several of them had begun watching Ethan very closely. He noticed it too. For the first time all day, he shifted uncomfortably in his chair, not because anyone had accused him of something new, because uncertainty had entered the room. Manipulative personalities often thrive on controlling information. The moment they lose that control, their confidence begins to crack. After nearly 20 minutes, counsel returned. The defense attorney looked different, not defeated, concerned. There's an important distinction. He requested permission to speak privately with his client. I granted it. They moved several feet away. They whispered intensely. Ethan shook his head repeatedly, then more aggressively. His attorney remained calm, pointing toward specific pages inside the file. Finally, Ethan said something loud enough for only a few people nearby to hear. She wasn't supposed to keep copies. That sentence echoed in my thoughts long after the words themselves disappeared. He realized what he'd admitted only after he said it. His attorney closed his eyes for a brief moment, not in frustration. In resignation, years of courtroom experience have shown me that truth often escapes through surprise. Prepared lies require planning. Unexpected admissions require only pressure. The proceedings resumed. Sarah's attorney requested permission to call the source of the documents. Moments later, the courtroom doors opened. A woman stepped inside, Lauren Hayes, mid-30s, former executive assistant. She looked nothing like someone seeking attention. No dramatic entrance, no theatrical expression. She appeared exhausted, as though carrying something she'd wanted to tell for a very long time. She was sworn in. I watched Ethan carefully. He never looked directly at Lauren, not once. Instead, he stared straight ahead. That caught my attention immediately. Earlier, he'd looked at everyone. Sarah, the attorneys, even members of the gallery. Now, he refused to acknowledge the one witness who had worked beside him for nearly 4 years. That wasn't confidence, that was avoidance. Sarah's attorney began gently. "Miss Hayes, how long did you work for Mr. Brooks?" "Almost 4 years." "What were your responsibilities?" "I managed schedules, financial correspondence, client communications, internal records, routine answers, calm answers. Then came the question that changed the atmosphere. Why did you leave?" Lauren hesitated. Not because she didn't know the answer, because she was deciding how much truth she was prepared to reveal in public. Finally, she spoke. "I didn't leave." The courtroom fell silent. "I was fired." "Why?" Another pause. This one longer. Because I refused to delete company records. No one moved. Even Ethan remained perfectly still. Too still. Sometimes silence becomes louder than testimony. Sarah's attorney displayed one of Lauren's preserved email archives. The metadata matched company servers, dates aligned perfectly. Recipients matched financial records already admitted into evidence. One by one, the pieces began fitting together, not conclusively, not yet, but unmistakably. Lauren explained that she'd been instructed to alter internal payment descriptions after transfers had already occurred. When she questioned the requests, she was told they were administrative corrections. At first, she believed them. Then she discovered duplicate ledgers, two versions of the same financial history, one for clients, one for internal use. The defense objected repeatedly. Some objections were sustained, others overruled. That's how real trials work. Evidence enters slowly, piece by piece, never all at once. Then Lauren reached into her bag. I have one more document. The defense immediately stood. So do I thought. Before she could hand it to the clerk, Ethan finally reacted. He rose to his feet without permission. No. Just one word, sharp. Immediate, every eye in the courtroom turned toward him. His attorney quietly urged him to sit down. He didn't. Instead, he stared directly at Lauren for the first time that entire day. His voice was lower now, more controlled. You don't know what you're doing. Lauren didn't answer. She simply handed the document to the bailiff. As it made its way toward the clerk's desk, I noticed something I had not seen once during the entire trial. A single drop of sweat rolled down Ethan Brooks's forehead. The man who had walked into my courtroom believing he controlled every conversation had just realized someone else might control the ending. I looked down at the document as it reached my bench. At first glance, it appeared to be nothing more than an ordinary internal memo. But halfway through the first page, I saw one sentence. I read it twice to make sure I hadn't misunderstood. Then I looked back at Ethan, because if that sentence could be authenticated, this case was no longer about a broken business agreement. It was about a deliberate scheme that reached far beyond Sarah Mitchell, and someone else, somewhere, was almost certainly still in danger. I have often said that the most dangerous moment in any courtroom is not when someone raises their voice. It is when everyone suddenly becomes quiet for the same reason. That afternoon, I experienced exactly that. The internal memorandum now rested in front of me. I had not admitted it into evidence, not yet. No judge should ever allow curiosity to outrun procedure. Still, even a brief review told me one thing. If the document proved authentic, this case was about to become something entirely different. I looked toward both attorneys. The court will determine admissibility before this document is discussed before the jury. Neither side objected. That surprised me, especially the defense. Normally, attorneys fight aggressively to keep potentially damaging material away from jurors. Instead, Ethan's attorney looked almost defeated. I noticed he wasn't watching me anymore. He was watching his client. That shift mattered. Lawyers don't usually fear documents. They fear clients who become unpredictable. I ordered the jury escorted to the deliberation room while legal arguments took place outside their presence. As the jurors filed out, several glanced back at Ethan, not with suspicion, with curiosity. They sensed they were missing something important. Once the courtroom doors closed, I turned my attention to the attorneys. Counsel, I began, explain why this document should or should not be admitted. Sarah's attorney spoke first. He explained that Lauren Hayes had preserved the memo from company servers before her dismissal. He presented digital authentication records, DATMIME routing information, server timestamps, backup logs. Each layer strengthened the chain of custody. The defense challenged every step. as they should, but something unusual happened. Each objection sounded weaker than the one before, not because the lawyer lacked skill. He was exceptionally capable because he appeared to know where the evidence was leading. Then I asked the question that changed everything. Mr. Brooks, were these internal communications ever disclosed during discovery? His attorney answered before Ethan could. No, Your Honor. I waited. Silence. Then I asked another question. Were they requested? Again, his attorney answered. Yes. Another silence, longer this time. I've learned that silence inside a courtroom has different meanings. Sometimes it reflects uncertainty, sometimes respect, sometimes guilt. This silence felt heavier than any of those. Finally, I looked directly at Ethan. Mr. Brooks, you may answer. He cleared his throat. I don't remember. I almost smiled, not because the answer amused me, because I had heard it thousands of times. People remember conversations from 10 years ago. They remember exact dollar amounts, specific addresses, tiny disagreements, but when confronted with potentially damaging evidence, memory suddenly becomes unreliable. Jurors notice that pattern. Judges certainly do. I asked no further questions. There was no need. Sometimes the first answer tells you everything. After reviewing the authentication materials, I ruled that the memorandum could be admitted for the limited purpose of establishing company procedures, subject to later foundation through witness testimony. The jury returned. The room settled. Lauren resumed the witness stand. Sarah's attorney approached the evidence monitor. He displayed the first page. Nothing remarkable, routine administrative language. Expense reports, vendor references, policy reminders. Then he scrolled downward. Near the bottom appeared a section highlighted by Lauren. Months earlier, the courtroom grew still. The memo instructed senior staff to maintain 2 categories of financial records, one labeled client review, the other labeled executive only. That alone wasn't illegal. Many companies maintain confidential internal records, but the next paragraph changed the air inside the courtroom. It instructed employees to delay disclosure of disputed transfers until client objections become legally manageable. I watched the jury. Every member looked up simultaneously, not at the screen. At Ethan, people often wonder how jurors evaluate credibility. Moments like this answer the question, evidence speaks. People react. The combination becomes powerful. Sarah quietly lowered her head. She wasn't celebrating. She looked heartbroken. There is a profound difference between suspecting someone betrayed you and seeing written proof that they planned it. Across the room, Ethan remained expressionless. Almost years on the bench have taught me to focus on the eyes. The face can lie. The eyes struggle. For the first time all day, Ethan blinked rapidly, a stress response. Brief, involuntary. His attorney requested permission to conduct cross-examination immediately. Granted. He approached Lauren carefully. No aggression, no raised voice, just measured questions. Hayes, did you personally write this memorandum? No. Did you personally witness Mr. Brooks draft it? No. So your testimony is based on what you observed within the company? Yes. The defense nodded. A reasonable strategy: separate the witness from direct authorship, recate doubt. Then he asked one final question. How can you be certain this document wasn't altered after you copied it? Lauren didn't answer immediately. Instead, she reached into her folder. I was hoping you'd ask. She produced another document, then another, then a small external hard drive sealed inside an evidence bag. The defense attorney froze. Lauren spoke calmly. I preserved complete server backups before I was terminated. Even I wasn't expecting that. Neither attorney had mentioned complete backups during pretrial motions. Sarah's attorney looked genuinely surprised. So did the defense. And surprise in experienced lawyers is extremely rare. Lauren continued, I turned everything over to federal investigators months ago. The words landed like a stone dropped into still water. Federal investigators, not private consultants, not accountants, federal investigators. A quiet murmur spread through the gallery before I instructed everyone to remain silent. I glanced toward Ethan. His confidence finally disappeared, not gradually, instantly. His posture collapsed into the chair. The carefully rehearsed smile vanished. He looked toward his attorney again, making for reassurance. There wasn't any. His lawyer whispered something. Ethan shook his head, then whispered back. The attorney leaned away from him slowly, deliberately. That movement stayed with me. Lawyers stand beside clients. But occasionally, a client says something that forces even their own attorney to create emotional distance. I couldn't hear their conversation, but I didn't need to. Bady language often finishes the sentence words begin. Sarah's attorney requested permission to call one final witness before the day ended. I reviewed the schedule. Time remained. Proceed. The courtroom doors opened once again. A man wearing a dark business suit entered. No uniform, no badge displayed, just a leather portfolio. He walked with quiet confidence toward the witness stand. The clerk administered the oath. Sarah's attorney smiled slightly. Please state your name and occupation. The witness looked directly at the jury. My name is Special Agent Nathan Reynolds. The entire courtroom seemed to stop breathing. He continued, I am a forensic financial investigator with the Federal Bureau of Investigation. Every eye turned toward Ethan Brooks. His face lost every trace of color. And before Agent Reynolds said another word, I realized this civil trial had just crossed into territory that no one, except perhaps Ethan himself, had anticipated. There are moments in a courtroom when everyone realizes they are no longer watching an ordinary trial. I've witnessed that moment only a handful of times in my career. This was one of them. As Special Agent Nathan Reynolds adjusted the microphone, the courtroom became so quiet that I could hear the faint hum of the evidence monitor behind him. No whispers, no papers shuffling. Even the spectators in the last row seemed afraid to move. I reminded the jury of the limited purpose of the testimony and instructed them not to speculate beyond the evidence presented. Then I nodded to Sarah's attorney. You may proceed, Agent Reynolds, he began. Would you briefly explain your role in this investigation? The agent answered with remarkable composure. My team investigates complex financial fraud, digital evidence, and interstate financial crimes involving electronic transactions. No dramatic language, no exaggeration, just facts. The most persuasive witnesses rarely try to persuade anyone. They simply explain what they know. Did your office receive materials from Lauren Hayes? Yes. When? Approximately 8 months before today's hearing. I looked toward Ethan. He had stopped taking notes. Earlier in the day, he had written constantly, occasionally whispering suggestions to his attorney. Now his legal pad remained untouched. That, too, is something I've learned to notice. When confidence disappears, routine disappears with it. Agent Reynolds continued. My office obtained search warrants for multiple financial servers, cloud storage accounts, and archived communications associated with Mr. Brooks' companies. The defense objected. Relevance. I considered the objection carefully. Overruled. The testimony directly related to the authenticity of the evidence before the court. Procedure required that the jury understand how the records had been verified. Nothing more, nothing less. The attorney approached the evidence monitor. Agent Reynolds, did your investigation confirm whether these electronic records were authentic? Yes. How? We compared the original server images, cloud backups, email routing logs, banking metadata, and third-party financial records. He paused. Every independent source matched. The courtroom remained silent, not because anyone was confused, because everyone understood what those words meant. The evidence wasn't supported by one document. It was supported by an entire digital ecosystem. I've often explained that technology has changed the courtroom. Years ago, people believed destroying paper destroyed evidence. Today, deleting one file often creates 10 new records somewhere else. Digital footprints are stubborn, sometimes more honest than people. The attorney displayed a timeline. It stretched across the screen. Transfers, downed on records, downed area appointments, video conference logs. Everything aligned with astonishing precision. One by one, each promise Ethan had made to Sarah appeared beside a corresponding financial movement. The pattern was impossible to ignore. Drat spore, delay, excuse, repeat. I watched the jury. Several members exchanged brief glances before quickly looking back toward the screen. Jurors are instructed not to communicate, but human beings communicate anyway. A raised eyebrow, a tightened jaw, a silent breath. I've learned to recognize those conversations. Then Agent Reynolds said something that changed the trial forever. Our investigation uncovered one additional recording. Sarah's attorney nodded. Please explain. It was not created intentionally. Another pause. It came from an automated conference recording system. Now I leaned forward slightly. So did nearly everyone else, the agent continued. A company video meeting was automatically archived after participants forgot to terminate the session. The defense attorney slowly closed his eyes. Just for a second, he understood what automated recordings often mean. People stop performing once they believe cameras are off. The attorney asked the question everyone wanted answered. Who remained in that conference? Agent Reynolds looked down at his notes. Mr. Brooks and 2 senior executives. The recording had already been authenticated. Both parties had stipulated to that fact moments earlier after reviewing the chain of custody. The attorney requested permission to play a brief excerpt. I reviewed the foundation one final time. Everything complied with the rules of evidence. I looked toward the jury, then toward Ethan. Finally, I gave a single nod. Proceed. The screen remained black. Only audio filled the courtroom. At first, there was ordinary office conversation, someone discussing invoices, someone mentioning travel schedules. Then chairs moved. A door closed. One executive laughed quietly. Another voice asked, "What about Mitchell?" There was a short silence, then Ethan answered. I recognized his voice immediately, calm, relaxed, confident. She'll keep waiting. Another voice asked, "And if she sues?" Ethan laughed, not loudly, casually, as though discussing anyone figures it out. He paused. The money will already be somewhere they can't touch. No one moved. The recording continued. What if someone talks? Another brief silence. Then Ethan spoke again. They signed everything. A chair scraped across the floor. They'll blame themselves before they blame me. The recording ended. I have presided over homicide trials, violent assault cases, catastrophic fraud. Yet I will never forget the silence that followed those final words. It wasn't merely quiet, it was heavy. Sarah closed her eyes. A single tear rolled down her face. She wasn't crying because she had lost money. She was grieving the realization that every apology, every reassuring email, every promise had been calculated across the courtroom. Ethan stared at the table. For the first time that day, he had nowhere else to look. His attorney stood slowly. He approached the bench. Your Honor, his voice had changed, measured, careful. I request a brief recess to confer with my client. Granted, the jury exited once more. As soon as the courtroom doors closed, something happened that no television audience ever expects. Ethan turned toward his attorney. He wasn't whispering anymore, he was pleading. You said they couldn't get that recording. His attorney remained perfectly still. I didn't know it existed. I promised to defend you, not to perform miracles. Then Ethan did something I had not seen in decades. He reached across counsel table and attempted to gather the exhibits into his briefcase. The bailiff stepped forward immediately. Sir. Ethan froze. For one brief moment, he looked like a man trying to outrun consequences that had already arrived. He slowly released the documents, sat back down, covered his face with both hands. When the jury returned, the transformation was impossible to miss. The man who had entered my courtroom wearing confidence like armor now looked defeated. Sarah's attorney rose one final time. No further questions. The defense stood. He adjusted his jacket, looked toward the jury, then looked at me. Your Honor, he took a slow breath. The defense rests. No witnesses, no explanation. No attempt to rebut the recording. Nothing. I had seen strategic decisions before. This wasn't strategy. This was surrender. But despite everything the jury had just heard, the most unforgettable moment of the entire trial was still waiting, because before deliberations could begin, Ethan Brooks unexpectedly stood up, looked directly at me, and asked to speak. Not through his attorney. Personally, what happened during the next 5 minutes would become one of the most widely discussed courtroom moments of my entire judicial career. When Ethan Brooks stood without waiting for his attorney, I immediately understood two things. First, whatever he was about to say had not been rehearsed. Second, his lawyer did not want him to say it. You learn to recognize that look after years on the bench. The attorney reached for Ethan's sleeve, almost instinctively, then stopped himself. He knew the rules. He knew his client had the right to speak if the court allowed it. I looked directly at Ethan. Mr. Brooks, before you say another word, understand that anything you choose to say in this courtroom may become part of the record. He nodded. I understand. His voice was completely different from the one I had heard that morning. Gone was the arrogance. Gone was the sarcastic confidence. Even his posture had changed. He looked like a man who had suddenly realized the room no longer revolved around him. The jury watched him without blinking. Sarah sat motionless. Lauren Hayes folded her hands together, saying nothing. Special Agent Reynolds remained exactly as he had been throughout the trial. Calm, unreadable professional. Ethan took a long breath. I never thought he stopped, then tried again. I never thought she'd fight this hard. He wasn't looking at Sarah. He was looking at the floor. That struck me immediately. Throughout the trial, he had avoided accountability by controlling where he placed his attention. Now he couldn't bring himself to meet the eyes of the very person he had wronged. I thought she'd eventually give up. Silence. I thought everyone always does. Those words stayed with me, not because they were legally significant, because they revealed something far deeper. Over the years, I've learned that fraud rarely begins with money. It begins with belief, the belief that other people are too trusting, too afraid, too exhausted to resist. Predators often count on human fatigue more than human weakness, Ethan continued. I've done business my whole life. I learned that if you sound confident, he laughed bitterly. People stop asking questions. No one interrupted him, not even his own attorney. He continued speaking as though he had forgotten everyone else existed. I wasn't smarter than anyone. I was just louder. That sentence caused several jurors to exchange brief glances. It was perhaps the most honest thing he had said all day. Confidence can influence people. But confidence without integrity eventually collapses under the weight of facts. Then he finally looked towards Sarah for the first time since the trial began. "I'm sorry." She didn't respond. Not because she hadn't heard him, because some apologies arrive years too late. I've witnessed countless apologies from defendants. Some are sincere, some are strategic. As a judge, my responsibility isn't to measure emotion, it's to measure accountability, and accountability requires more than words. I asked Ethan one question. "Mr. Brooks," he looked back at me, "do you accept responsibility for your actions?" There was a long pause, long enough that I wondered whether he would retreat into excuses one final time. Instead, he quietly answered, "Yes." No explanation, qualification, no attempt to blame employees, no attempt to blame lawyers. Just one word, yes. I appreciated the honesty. It did not erase the conduct. But honesty, even when delayed, matters. I instructed the jury on the law carefully, methodically, as I always do. Emotion has no place in jury instructions. The law must remain steady. Even when the facts are deeply emotional, the jurors retire to deliberate. People often imagine deliberations lasting days. Sometimes they do. This one did not. Less than 2 hours later, the clerk informed me the jury had reached a unanimous verdict. Everyone returned to the courtroom. I looked across the room one final time before asking the foreperson to stand. The verdict form was handed to the clerk. She read it aloud. On every count submitted to the jury, they found in favor of Sarah Mitchell. Damages were awarded in full. Punitive damages followed. The findings supported intentional deception. The courtroom remained quiet. No cheering, no celebration. Justice is not entertainment. It is resolution. But the proceedings were not yet over. I turned towards Special Agent Reynolds. He rose, without drama, without emotion. He informed the court that, based on evidence authenticated during the proceedings, federal authorities would continue their criminal investigation into financial fraud, obstruction, and related offenses. He did not speculate. He did not overstate. He simply confirmed what procedure required. Ethan closed his eyes. For a long moment, he said nothing. The bailiff stepped beside him. There was no resistance, no anger. Only the unmistakable expression of a man who finally understood that consequences delayed are not consequences avoided. As he was escorted from the courtroom, he briefly turned back, not toward me, toward Sarah. She remained seated. She did not smile. She did not wave. She simply watched him leave. Sometimes that is what justice looks like, not triumph, not revenge, closure. After the courtroom emptied, I remained alone for several minutes. I often do after difficult cases. People assume judges forget the faces they see. We don't. Some cases follow us home. This was one of them. I thought about Sarah, a woman who refused to surrender simply because someone powerful expected her to. I thought about Lauren Hayes, who risked her career to preserve the truth. I thought about Agent Reynolds, who reminded everyone that facts, when patiently assembled, speak louder than confidence ever can. And I thought about Ethan Brooks, a man who believed intelligence meant staying one step ahead of everyone else. He misunderstood something fundamental. Real intelligence is never an excuse for dishonesty. Character is revealed when no one is supposed to be watching. Ironically, it wasn't a dramatic cross-examination that exposed him. It wasn't an emotional witness. It wasn't even my questioning. It was his own arrogance. He believed every camera had been turned off. He believed every record had been erased. He believed every person around him would remain silent forever. He was wrong on every count. If there's one lesson I hope you take from this case, it's this. Arrogance has a way of convincing people they're untouchable. But the truth is remarkably patient. It doesn't rush. It doesn't argue. It simply waits. And sooner or later, It arrives. I've presided over countless hearings, but this one still reminds me why justice depends not only on laws, but on ordinary people willing to tell the truth when it would be easier to stay quiet. Years later, I can still picture Ethan's confident smile when he first walked into my courtroom. I can also remember the silence when that confidence finally disappeared. Those two moments lasted only a few hours apart, but they taught a lesson that will last far longer. No matter how clever someone believes they are, no one is ever above the truth.